Hello, I'm Jennifer Stowell. Idea2IPO has been holding tech startup events in Silicon Valley for many, many years. We launched officially on February 1st, 2010. At that time, we had no members and no events on our calendar. At this stage, we have over 100,000 members among all of our meetup groups all around the world. We have organized, promoted, and produced over 2,549 events. By any standard, by any measure, we are the most active, most prolific startup event organization in the history of Silicon Valley, bar none. We organize venture capital panels, legal workshops, networking events, and more. These days, we are 100% online. We hold an event nearly every day of the week. Check out our schedule at idea2ipo.com. Our featured speaker is Roger Royse, one of the top venture capital attorneys in Silicon Valley. And he is passionate about helping entrepreneurs succeed. Ladies and gentlemen, Roger Royse. Roger, take it away.
Okay, thanks very much, Jennifer. Okay, can everybody see me? You are very happy to be here, I can tell already. And by the way, let me remove your spotlight. Okay, thanks, Jennifer, and happy early Valentine's Day. Thank all of you for being here today. Today we are going to talk about startups in a down economy. Although we're kind of debating here whether that should be startups in an up economy. It's hard to tell right now, but we're going to assume that, as I've been assuming for about a year now, that we are going to be heading into a recession because of what's going on out there. Because the worm is going to turn, and I would like everybody to be prepared when it does. So a couple of housekeeping items. First of all, I'm Roger Royse. I'm a partner with the law firm of Haynes and Boone. I want to thank Idea2IPO for hosting this event and making this available on their Zoom platform. This event is being recorded. I'm going to be using slides. You'll be getting a copy of the recording and the slides at the end of the event. Now, my next event is in 2 weeks, so we do this quite frequently. On the 23rd, we'll be back with another startup-related topic, so you want to stay tuned for that. Here's the agenda for tonight. I'm going to present for about an hour, till the top of the hour, till 8 o'clock Pacific. Then I'm going to take questions from 8 to 8:30. You're going to have questions as I'm talking. What you should do is put them in the Q&A dialog box down at the bottom of your screen. Don't put them in the chat, put them in the Q&A. Use the chat if you need to tell me something that I need to know immediately, like where you're from. But if it's just a question, let's collect all those and we'll get to them later. All right, the other thing that I need to tell you is who's in the audience. Or actually, you're going to tell me. So I'm launching a poll. I'd like to find out who is actually here. Okay, we've got with about about 3/4 of the respondents, it's about 50% startup entrepreneurs, about 10% investors, 10% service providers, a really big category of other. I'm really curious as to what that other is. Feel free to chat me who the other is, because I keep refining these polls, but I just never get everybody. So mostly startup entrepreneurs, a lot of investors here today, and quite a few service providers. All right, I'm going to end the polling with 76% of the vote counted. All right. The other thing I'd like to know, because we used to do these in the old days, we did these live. We'd all get together in a room and you meet everybody someplace in Silicon Valley. These days, of course, we do it remotely by Zoom. And the bad news is you don't get to meet everybody and exchange the business card. Remember those business cards? The good news is that we broadcast all over the world. So what I'd like to know is, where is everybody from? Who am I talking to today? I'm coming to you from Palo Alto area, heart of Silicon Valley. Where are you folks? It's 7 p.m. at night here. Okay, with looks like mostly Silicon Valley and other North America. We've got more people from Asia than normal here. We've got people from Europe, must be really late in Europe, Western Europe. Several people from Africa, several other. And okay, with 78% of the vote counted, 28% Silicon Valley, 39% other North America. Wow, that's interesting. Usually it's more heavily weighted towards Silicon Valley. The other thing that I want to mention is I have enabled the chat feature so that if you want to talk to each other, you can go ahead and do that. So if you want to tell people who you are, I posted my LinkedIn credentials in the chat, so you can find me on LinkedIn. Go ahead and post yours if you like, or anything else, who your company is, your website. If you're tweeting, and I already posted the hashtag, it's hashtag idea to IPO. So make sure you go ahead and tweet anything that you hear that you like, you don't like, or you just want to tweet. Okay, ending the polling. It's about a third Silicon Valley and about a third other North America. Alrighty, I think that takes care of all of my housekeeping items. So now comes the part of the program that you should not try at home. And this is the participatory part, because I need you to chat me and tell me that you can see my screen. And what you should see is a slide that says startups in a down economy. All right, can everybody see that? Let's see, I got 4 chats that say yes. All right, thank you. Thank you, thank you. You might win $1. Okay, first of all, I'm a lawyer, so a lot of what I'm going to be telling you is legal, but that doesn't make it legal advice. That's just me talking. Although I am a lawyer, like I tell people, I'm not your lawyer yet. So this is just generalized advice. You really need to find a lawyer about your particular specific situation if you want legal advice. Here's what I hope to cover tonight, although I doubt that I'll get through all of it, but I might. Talk about planning for the downturn that a lot of us think is coming. And not to be Debbie Downer, but we can't be in this bear market forever. So this is planning for the downturn. We're going to talk about the good, the bad, and the ugly of it. There are some good things that are happening right now that you can do. Part of that is some of the federal aid. I'm going to give you an update. We got new content that is right up to the minute on new federal aid and tax credits that's going on out there. We will talk a little bit about tax because people forget about that. And then we're mostly going to talk about all the things that I want you to watch out for and that you shouldn't do, and the mistakes that you shouldn't make in your company that might get you in trouble if your company doesn't do well. Now, I'm here in Silicon Valley. I work with startup companies, emerging growth and venture capital. So almost exclusively startups. And I got to tell you the secret. Sometimes startups don't succeed. Okay, sometimes they don't. You read about the ones in the paper that make it big and they become unicorns and decacorns, etc. But sometimes they don't succeed. And what I want to do tonight is I want you to come away from this with enough knowledge that in the unlikely event that your startup does not succeed this time out, you're going to live to fight again and do another startup. And that is true throughout startup lore and throughout startup history and throughout history. Just look how many times Abraham Lincoln lost elections before he became president. So there's no shame in failing at a startup, but you don't want it to drag you down personally. You want to be able to come out of it and be able to do it again. So why am I so concerned about this recession, or about this bad economy I keep talking about? Because honestly, from where I sit, it doesn't look that bad. And I'm going to tell you some statistics in a minute. That's why I say that. And I just want to give you a little bit of history. About a year ago at this time, we were doing these programs, and we were all talking about 2008, a little less than a year ago. And we were all talking about how the economy is going into 2008. And there was a very famous memo at that time, the Sequoia Black Swan memo, where Sequoia, a big venture capitalist here in the Valley, basically sent a memo out to all its portfolio companies and said, you better hunker down and start conserving your cash because bad times are coming. And those startups took it to heart, and Sequoia happened to be right. It was a really, really bad recession. That's what happened then. The good news is we got a lot of lessons out of that. There's a lot of lessons as to what startups can do if they're worried about the economy. Bain and Company, you might just Google it. They put out a really good report about a year ago. I think it's still relevant now about companies that hit tough times, how they can organize around 6 urgent priorities and weather the storm and get through this. Protecting their customers is really important. Protecting their employees, because that's a lot of value in your company. Modeling your finances, what they call defending revenue, which basically means keeping your customers. Stabilizing, reducing costs. And I really like this last one, playing offense. And we can talk a lot about playing offense. When things turn, there's usually an opportunity someplace else. And you'll see the really successful companies are the ones that are on top of it. Now, I'm involved with a company now that they opened a restaurant right before the pandemic hit. I want to talk about playing offense for a minute. And this is the good part of all this. Right before the pandemic hit, they opened a restaurant. It was one of a chain. They had to immediately close down. Now they didn't just close down and I'll go home and just hope that the economy would reopen someday. They closed down and went back into the lab and started thinking and scheming. And they came up with an online ordering system that was so successful for their restaurant that they've expanded it to other restaurants. And they spun that off. And that's now a new company that does nothing but facilitates online ordering for other restaurants. That's what you call playing offense. In fact, you can read about that story in my upcoming book, which I hope to get out this year. I'm playing offense too. I'm going to get a book out this year. It's a book about startup successes. So think about playing offense. Now, why am I talking so much about a recession? Because it doesn't really feel like a recession. There are a lot of businesses that are doing really well. Well, what does the press say? And this changes almost every day if you've been watching us. So in November, it's actually Roger, but you can call me Robert. I'll text it to you, the name of the startup later if you like. Somebody asked Robert what the name of the startup is. If I see Robert, I'll ask him. So November 2020, CBS reports a double dip recession is coming soon. Economists fear a double dip recession. So CBS, this is November. By January 5, Fortune says, well, wait a minute, we're in the fastest economic recovery in American history. You know, we're in such good times. Okay, a few days later, January 28, well, okay, the US is technically out of a recession, but we're a long way from healthy. Remember that double dip thing? You know what they mean by double dip? You can guess. And New York Times, as of this month, says, well, the economy is still doing well, improving faster than expected. And I can tell you that the venture capital financings are really strong. Take a look at what happened in 2020 in terms of VC financings. It was down a little bit, as you can see, in terms of number of deals, but look how much money was invested, okay? And that's my world, is venture capital, especially here in Silicon Valley. So it just doesn't look like a recession from where I'm sitting, but we have to anticipate that we might be back here in this, you know, we might hit another dip. So that's what I'm going to prepare you for. Now, why is venture doing so well? I mean, why are companies doing so well? Why are they spending so much money? Where is all this optimism coming from? Well, again, playing offense. There are a lot of businesses that have done really well over the last year. E-commerce comes to mind. People doing e-commerce. How else can you do commerce but on e-commerce these days? And online services generally. Food safety was a big sector last year. By the way, did you read in the paper today or yesterday? It was today. I heard it on the radio this morning. It was somebody was arrested for actually poisoning a water aquifer, so a water supply. And they managed to catch him before he could do any damage. He was attempting to. But the reason that's a big story, because I used to live in New York City, I used to jog around that big reservoir. I always thought it was a little insecure. The reason that's a big story is that they did electronically. They did it through hacking. And this is something we've all been worried about for a long time. And now people are really worried about it because somebody almost pulled this off. So cybersecurity, where cybersecurity meets food safety, I've been seeing a lot of buzz about that over just the last 3 months. I talked about it about a year and a half ago on a stage in Toronto, and now it's actually happening. And you're going to see, I think, that's another place where companies are going to do well because of what's going on in the news and in events. Insurance tech has done well. It's in an industry that really needed some help getting technological. Telemedicine has been huge. It's been huge. We have a precision health, digital health, and precision medicine group in our firm, and it is probably our fastest growing sector in our firm. So telemedicine, digital health, anything to do with health tech. By the way, as big as health tech is here, health tech last year grew 3 times in China. It tripled in China in terms of a sector. So as a worldwide sector, that's another big one. Housing, just anecdotally, I've been seeing a lot of companies. I read about a company last week that raised $100 million. It's basically a solution that finds housing for people. I've been seeing several. Yeah, go ahead and text that link to all the attendees if you like, the water link. But anyway, housing startups are doing well right now because people are very concerned about housing. We got a real problem, especially here in California, with regard to affordable housing. And there are technology solutions that are attacking that. Supply chain, I was on a webinar this morning that the Wall Street Journal put on around food technology, and they talked about supply chain. So technologies that can improve the supply chain, because what we saw last year is how weak the supply chain is. It really is a chain. You get a weak link in that chain and it stops anything. Cybersecurity, I talked a little about. Education tech, it's been big for obvious reasons. And here's one that you're going to hear a lot more about, transformative tech. Transformative tech, and this is the technology that is concerned with health and wellness. And it's basically, I've been seeing a lot of companies, a lot of technologies that are using technology and data really to make people's lives better. And this is something that even the big players now are starting to put money into it. 500 startups has actually even identified this as a sector in which they're soliciting companies. That'll be the next big thing, by the way, that's my opinion. Okay, so let's talk about what's going on now. So somebody asked me on chat, do I think a recession's coming? Do I see any signs? I will tell you that I do think a recession's coming because I think someone's going to have to pay back these Paycheck Protection program loans at some point if they're not forgiven. And if they are forgiven, then someone else will have to pay it back. So eventually this is going to hit the economy. Our spending is now 100% of GDP. And I think that's just got to have some adverse effect down the road. So I'm very much a pessimist on this, but I'm an optimist on this. On what's going on and how you can position yourself and take advantage of it. So we all know about the Paycheck Protection loans, right? We heard about this all last year. These are loans from the government that you could use to spend on payroll, on rent, on mortgage payments, on additional operating type expenses. On top of that, we got tons of tax credits. Well, we got tax credits, I'll say on top of it. All of that has been. Well, before I get to that, the intention of these Paycheck Protection loans, this slide needs to be updated. It was 60% that had to be used towards payroll when they came out. Now it's up to 75%. But the intention was really to give companies money so that they could pay people and not lay them off. That was a whole idea. The loan was forgivable, right? It was forgivable to the extent that it was used towards payroll costs. And we've already into that forgiveness now. So there are a lot of companies that got a lot of money and they actually had those amounts forgiven. That was a huge incentive. Well, that was 2020. What about 2021? We now have what we call second draw loans. So companies that used up all of their first draw Paycheck Protection loan, they can take a second draw loan. And with that second draw loan, it's not available to everybody. And you have to have had a 25% reduction in gross receipts, but you can use that second draw loan just like you use the first Paycheck Protection loan. So I guess the moral of the story is that money is still out there. It's still available for companies that need it. Then there's also something called a Supplemental Paycheck Protection loan because we had new rules changing this all the time. So you could go back and actually get more money under a first draw loan. Now, what's been really interesting about this is that when the Paycheck Protection Program first came along, if you took a loan and you used that loan to pay expenses and then you had the loan forgiven, you didn't get a tax deduction for the expenses. So, which makes perfect sense, right? You didn't get a tax deduction. And I mean, just think about it. You get the money tax-free, and then you go spend it. If you got a tax deduction, you would make money on the transaction, right? You get $100 and then you get a $100 tax deduction, right? If you're in a 50% tax bracket, you just made $150. So that was a very reasonable law. California did not conform, of course. California oftentimes does not conform. But now the law has changed. The law has changed that borrowers who've had their loans forgiven can claim deductions for expenses, even if those expenses were paid with the loan amounts that were forgiven. That is huge. That is a huge benefit. So make sure you pay attention to that, this particular provision, because it is a huge government benefit. Last time I looked, California was not conforming to this, but that may change. It's under discussion. There are other types of loans. I won't spend a lot of time on them. All I want to tell you is that, and by the way, the economic disaster loans have been extended through the end of this year. So if you can't get a PPP loan, you can get an EIDL, what they call it, to loans up to $2 million. It's at a higher interest rate. The PPP is 1%. The EIDL is at 3.75, but they do have to be repaid. Okay. EIDL loans. And then I just want to mention, and this is not just during bad times or good times, but there are a lot of government resources available. There are a lot of government resources available, especially here in California. California has its own set of resources available. The SBA has lots of facilities available for small businesses. So just keep that in mind. And we could do a whole session on grants, government grants as well. Now, what I will tell you that a lot of the investors I know tell me that they don't think the grant money is worth the effort that it takes to get the money. So just take that for what it's worth. I hear that comment from time to time. It's a lot of effort, and I've been through that process, and it is a lot of work. Talk about red tape. The loans, not quite so much, but again, loans have to be repaid. So money is out there if you look hard enough for it. And then the other thing, I have to pause. I know we don't want to talk about taxes at 7:30 at night, but I want to talk about this employee retention tax credit, because this is another thing that came in last year. And it used to be 50% of wages up to $10,000 per employee per year. So that's $5,000 credit per employee per year. Okay, it's something, I guess. Well, the law has now been changed, and now it's been liberalized just recently. So now the credit is 70% of wages up to $10,000 per employee per quarter. And it's also been extended through June 30th, 2021. Now, you have to meet some requirements. The biggest one is that you have to have a reduction in your quarterly gross receipts. But if your business really has been impacted and you really are feeling that downturn, you can recoup some of that through an employee retention tax credit. Here's an interesting thing about this tax credit. It's what we call a refundable tax credit. It's refundable against payroll taxes. What does a refundable tax credit means? An advance refundable tax credit, in fact. It means that you fill out the forms, you go to the IRS, and they send you a check. They actually, it's not that you use the credit against future taxes for the next 10 years. It's that it's a refundable advance credit. So they give you a check for the amounts that you paid in past years for payroll taxes. So that's huge. That's just money. That's free money. All righty, I'm done with the good. We're at 7:30. I'm going to move on to some of the bad. So those of you who are struggling with debt and you're going to get in this position where you have to do something with that debt or do something with your finances, you're going to do what we lawyers call a workout. And that workout might mean that you tell your creditor, look, I can't pay you back, but I got plenty of equity. Would you like some equity? Serve them up some equity. Or you might say, look, I can't pay you back 100 cents on the dollar. I can pay you 50 cents on the dollar or something. And then the final, I'm just going to lump this into workouts, what we call a recapitalization, a recap. So you convert your investors' preferred stock into common stock. All righty, let's drill down on a couple of these things. What I'd like you to know about canceling debt in your company is that the general rule is that that's going to be taxable. And you could end up in a world of hurt canceling debt in your company. Because typically, if you borrow $100 from me and I come to collect and you say, sorry, I ain't got it, and I say, that's okay, I'll cancel it. Well, you've got $100 of income. And you might say, well, what's the big deal? The big deal is you're going to owe tax on that. You're going to have to pay the IRS, and you're not going to cancel that debt, not unless you're in bankruptcy after 3 years even. So it can be a really bad result. Now, there are a lot of ways around this, and I want to talk a little bit about that. I just be aware of this before you go into it. So number one, if your company is going to give somebody equity in exchange for debt, that can be an exception, right? That can be an exception if the equity is worth the amount of the debt. Your company borrowed $100, has a note for $100. You can't pay it, and you say, look, we'll give you $100 worth of stock. No COD income as long as that stock is really worth $100. If it's not worth $100, you might have some income. I don't want to spend a whole lot of time on this. I just want you to get the concept because I don't want to put you all to sleep. But just keep in mind that COD is real, and there are several ways. There's numerous exceptions. You could drive a Hummer through all the exceptions in COD. Number one, if you're in bankruptcy, you're not going to owe tax because your debt gets canceled. If you happen to be insolvent, what does insolvent mean? Your debt exceeds your assets. To the extent of that insolvency, to the extent that your debt exceeds your assets, you're not going to be taxed on forgiveness of debt. Any farmers, you get your own statutory exception. Anybody in a real estate business, you can go back and readjust the price. That happens all the time. That's one that is going to happen. That's one that I feel like business is in a lot of trouble if you're in commercial real estate. I think in fact, we're seeing it already. Without naming names, I'm seeing it already. There's been some quiet foreclosures of commercial properties going on. That's the bad news. The good news is, well, we can use the qualified real property business indebtedness exception to. By the way, anyone remember Donald Trump? He used to be president. This is how he got out of paying $1 billion taxes on almost $1 billion worth of income. I didn't see his tax return. I don't know that for sure, but as a tax lawyer, I'm pretty darn sure that's how he did it. So this is a big one. And then residence interest, we won't talk about here. All righty, let's move off of this tax thing for a minute. If you want to hear more about it, call me up. I could talk your ear off about taxation of cancellation of indebtedness. I want to move into, so those are the bad things. That's kind of bad if you can't repay your creditors. It's kind of bad if you got to pay a little bit of tax or have to structure around it. You got to pay me to help you structure around it. What's really ugly, though, is if you get tagged with those debts. You formed a startup company. Someone told you that you should go get convertible debt to not sell stock. So you've got a bunch of convertible debt outstanding. And turns out you know how convertible debt works, right? The lender gives you it's like the lender makes the loan, and you either repay the loan or convert it to equity in your next preferred stock financing. You don't do a preferred stock financing, guess what? You got to repay the debt. Now you can't pay the debt. Okay, that's bad, but let's keep it from being ugly. How does it get ugly? It's when you've guaranteed that debt. Okay, when you've guaranteed that debt. So what is a guarantee? It's just what it sounds. It's where you personally agree to answer for the debt. You should never do that. You should never do that. Now, having said that, people are going to insist that you do that. When will that happen? Your lease. You've probably personally guaranteed your lease. We can't get you out of it if you did, but not easily anyway. But just be aware if you've got guaranteed debt, because you're going to want to make sure that that debt gets repaid. What other types of debt are probably guaranteed? Probably your line of credit, your bank debt. Banks are pretty savvy. They get lines of credit. Now, this can get very complex. And I'm just going to mention a couple of things because you might think that you've guaranteed your debt, but you need to look at your documents. One is what they call springing recourse guarantees. In other words, you don't guarantee it unless something happens. And what is that something? A lot of times it's these bad boy clauses. And if you look at your documents, they might say, look, this is non-recourse debt. We're not holding you personally responsible for this unless you lied on your loan application. It happens more often than you think. You went and transferred a bunch of your assets, so we can't get them. You diverted cash. You did one of these long list of things. Now, I've seen bad boy guarantees that aren't all that bad, right? You don't have to be that bad to trigger these. And you can bet that the bank is going to be looking for a way to hold you personally responsible. So be very sensitive to this. And then guarantees are just contracts, so they can be wired however you like. Limited guarantees, they can be top dollar, bottom dollar, they can be limited to a percentage of debt. We do that a lot, by the way. I draft a lot of documents that say we have a personal guarantee in this debt, but only up to 51% of the amount of the debt. There's good reasons for doing that. We won't get into it. Now, there are defenses to guarantees, especially here in California. Our code is full of them. That's the good news. The bad news is that every well-drafted guarantee is going to have you waive all of those defenses. But nevertheless, there are a few things you should think about. Fraudulent inducement. Did you know what you were signing? Guarantees can be revoked under our civil code unless you waive that right. Typically, the bank can't increase your risk. That'll let you out of the guarantee, etc. All right, moving right along. Force majeure. This is something that we all heard a lot about in 2020. And this is, I'm only putting it up here because this is a way that people might want to get out of a contract that turned out not to be a very good contract because of what's happened. It's a little late now, right? If you entered into a contract a year ago at this time, or maybe a little earlier, and you had a force majeure clause, you might have been able to get out of it because the pandemic came along and it frustrated the purpose of the contract. Right now, we're all drafting around this. We're all defining very clearly in the documents whether pandemic is an event of force majeure that lets people walk away from the contract or not. Let's use an example. Suppose you're in the restaurant business and you lease space for your restaurant, and the next day there's a government shutdown order and you can't operate a restaurant. All right, so you might rely on your force majeure clause. Are you going to win that case? Are you going to win that case? The answer is, it depends. This is a matter of contract. You got to look at the contract. Because almost every contract will deal with something like this. If there's nothing in the contract at all, you might be better off, because then you can rely on common law force majeure. Typically, this is dealt with in the contract. And sometimes people have been winning some of those cases, and people have been losing some of those cases. It just depends on their agreement. Closely related to force majeure is this idea called impracticality, and that's just an excuse in performing. Same kind of idea, you get the point. And then frustration of purpose. And that's the idea, again, very similar, that there's some unforeseen event that underlined the party's purpose for entering into the contract. I got to pause and give you a case about this because this rule came over, like most of our law here in the United States, from old England. And so there was this fella. He rented a hotel room that sat on a corner of a busy street, and the reason he rented it is because there's going to be a parade that day, and the Queen would be riding by in her carriage, and he would have this perfect view of the Queen from that corner. So he rented the room, waited for the Queen, but then the parade got canceled. And he said, I'm not paying for the room. Frustration of purpose was out of our control. I mean, I only rented the room so I could see the Queen. That's the frustration of purpose doctrine. It has broader application than that today, just so you know. And again, whether COVID's going to get you out of this, that depends on the contractual language. Or whether by the way, not just COVID, whether the next disaster, maybe we'll have another round of forest fires, right? Maybe we'll have an earthquake. Maybe we'll have a flood. Maybe we'll have mudslides. This is California, by the way. All of those things could happen on the same day. So something to just keep in mind, there might be ways out of those bad events. And if there's not, you ought to be taking a look at your business interruption insurance. Okay? You might have insurance. Now, what I have found over the last year, because I've had a lot of people taking a hard look at their insurance policies, they say that insurance companies are in the business of denying claims, not paying them. Take a hard look at those insurance. Believe it or not, I saw insurance policies, business interruption insurance, that had carve-outs for pandemics entered into years ago. How did they know? How did they know? You know, because they're insurance companies. That's why. So take a hard look at them and know what you're getting into and maybe shop around. Okay, speaking of insurance, going to shift gears here a little bit. When things do start to go bad for your company, if they do, and it might be because it's a startup, or it might be because of what's going on in the world. When the claims start coming along, again, you want to protect yourself. I want you to be able to live to fight another day. So number one, you want indemnification. It's your company, so you're on the board of directors or you're an officers. You want to get insurance to cover your acts because you have fiduciary duties in both those capacities. You have more fiduciary duties as a director, by the way, but either case, you're going to be on the hook. You don't see officers sued that often. Breach of loyalty is what you see officers sued for, but not so often for breach of the duty of care. So keep in mind that you can insure against this. You can get indemnification from the company. That means the company will reimburse you if a creditor or a shareholder sues you because you're a director. And it happens more than you might think. And then you can insure against that. Now, we'll maybe talk a little bit more about fiduciary duties later, but like Miranda rights, you should know that you have them. But unlike Miranda rights, they're going to be a bad thing if your company gets in trouble. You have a duty of care. All right, you have a duty of care. You're protected by what they call the business judgment rule. You don't have to be a good businessman. You just have to be a careful one. Okay. I don't know if anyone's going to get sued for shorting GameStop, but that seems to me like be a really good example of duty of care. You know, really bad move, but you know, it's probably within the business judgment rule. And then you have a duty of loyalty, meaning you can't self-deal, you can't enter into contracts with yourself. Okay, that's liability insurance, protects your personal assets. And also keep in mind, there's always willfulness carve-outs. Nothing's going to protect you from your own willful activity, so don't be a bad actor. All righty. Moving right along to more of the ugly. Fraudulent transactions. So we used to have this thing called the Uniform Fraudulent Transfer Act. Back when I used to litigate, I was on both sides of that issue. It's now the Uniform Voidable Transactions Act. And the reason the name has been changed is because you don't have to be very fraudulent to get nailed under the Fraudulent Conveyances Act or Fraudulent Transfer Act. You really only have to transfer something while you're insolvent and not get a reasonably equivalent value. So this happens way more than you might think. Let's draw on 2020 again. Did anybody see that show, Tiger King, something like that? Tiger King, that old boy in Oklahoma. I'm from the Midwest, so I can say old boy. That old boy in Oklahoma who got in all that trouble. Do you remember he got sued? He had big judgments against him. He had this big tiger preserve. And the show itself was kind of fuzzy as to what happened. But the next thing you know, he transferred it to his mother. And the next thing you know, his mother's being sued by the creditor. And the lawsuit basically wipes her out too, as well as him. I know exactly what happened there. I know exactly what happened there. I don't even have to watch the rest of the episode. I've seen that 100 times, right? In that sort of scenario, what happens is you really can mess somebody's life up if you transfer property to them without a reasonable consideration, or if you transfer property to somebody in order to hinder or defraud or delay your creditors. That's a crime in California. And it's also actionable under the law of all of the states. And what it means is that the transferee is going to get sued for the amount of the water, basically. They're going to get sued for the amount, you know, usually it's just a suit for rescission, give me the property back, but it actually could be a suit for damages. Because of that transfer, you hindered me and now you owe me the money. So don't make a bad situation worse by transferring property, by making a fraudulent conveyance of property. That's the moral of the story from Tiger King. That's what I got out of it anyway. And then finally, personal liability. Again, we talked about personal guarantees, contractual obligations. You could be a co-obligor, meaning that you are liable for a debt right along with your company. Pledges and security interests. We see security interests. You pledge your personal property to secure the debt of a company. So just be aware. All right, I'm going to talk about a few other things here before we move off of some of the ways we can get in trouble. And these are the big ones. These are the ones that, in my experience, I see wipe people out more than anything else. And kind of the number one, biggest one is personal liability for a willful failure to pay payroll taxes. So here's the issue here in the United States. So we have a withholding regime. So your employees, there's payroll taxes. You withhold those taxes, you put them aside in a separate account and as a trust fund for the government. And then at the end of the day, the week, the quarter, you can go ahead and transfer that money along with the proper forms to the government. They're trust fund taxes. You're holding that money for the government. So many companies, once they get in trouble, they say, well, we've got this big money that's not due until the end of the quarter. I can use it to pay people and pay them here, or I can leave it in that account. I think I'm going to pay people and keep them working, and we'll recover it. You know, that big collection is going to come in by the end of the quarter, and then I'll make my quarterly tax payment, payroll taxes. Anybody who has anything to do with that is going to be personally liable. The federal government, and especially the state of California, are extremely aggressive on this issue. It's one of the first things they do is they look for responsible persons. It's just as tempting as it is, don't do it. Don't ever do it. Don't ever use payroll taxes to fund anything other than payroll taxes. You will get tagged. Now, I've had cases where the IRS has gone after, first of all, everybody who's got their name on any of the accounts. If you can sign a check for a company, you could have made that payment. You're liable. I've seen them go after quite aggressively and chase, not concede even at appeals, the bookkeeper. Because they were able to go in and make payments from the account. So it's a very, very risky thing to do. So that's number one. It's probably the number one thing where people get in trouble, when companies start to get in trouble, where parties can have personal liability. Similarly, we have similar rules for sales tax. I've never seen that enforced, but the statute is there. We have similar rules for other types of payroll and withholding taxes. Moving along, I'm just going to go through these kind of quickly, but bad checks and credit cards, usually somebody is guaranteed the credit card. Bad checks, that's criminal liability. If you sign a check, even if it's a company check, don't do it. Here's one, improper distributions to shareholders. Company's insolvent, you pay a distribution or a dividend, shareholders are going to have to put that money back. Not only that, the directors who authorized it are going to have liability to the company. Improper loans to directors. That could impose liability on the directors who authorize it, as well as the party that got the money. So if a company starts to get in trouble, don't do this stuff. Now here's a big one. California Labor Code. And as California goes, so goes the rest of the country and the rest of the world. And in California, there were always ways to tag an individual officer for unpaid wages of the company. But you had to prove a few things. Mostly in intention. As of a few years ago, we have a labor code provision that basically imposes liability on any person acting on behalf of the employer who doesn't cause wages to be paid. And we're seeing those cases now. So officers can have personal liability for unpaid wages. So that's another one. I would put it right behind trust fund taxes that you just got to make sure get paid. Erisa, this is benefit plans, 401k deferrals, things like that. If your company has a benefit plan or a 401k, you can't get behind in that. A couple of other things, CERCLA, that's environmental, that's personal liability. Here's one I want to pause on, because this is another sleeper that you're not going to believe that it's true until you read about it in a pleading. Fraudulent failure to pay. And I've known people that have won on this, that have recovered on this theory. They say, look, yeah, we had a contract, and it was a contract of me and your company, and you said the company was going to pay. But the time we entered into that contract, you knew you weren't going to pay. You knew the company wasn't going to pay me. You knew it had no money. You knew it had no prospects. You know, I relied on you telling me that the company was able to pay, and it wasn't. That is a misstatement of a material fact, not an opinion, not a future fact, a material current fact. That's fraud. That's fraudulent failure to pay. And the California courts have been pretty darn liberal about allowing that case. In fact, they've been pretty liberal in their ability to find fraud in cases that you might not think are fraudulent at all. So be really careful about this one. And then, of course, there's the statutory frauds. There's wire fraud. There's bank fraud. All sorts of ways you can get in trouble once. And this is not just troubled companies. This is companies that could be doing well, right? You can violate our blue sky laws, our securities laws, even while you're doing well, just to raise more money. And it happens all the time. What I'm saying is that there could be personal liability for people who participate in these violations of these particular statutes. Okay, here's another one, corporate alter ego. I'm going to pause on this one for a minute too. I have heard so many litigators, and I'm not a litigator, I'm a happy lawyer, I'm a business lawyer. I'm going to make your life better, not worse. I'm not going to take it apart, I'm going to put it together. However, I've heard so many litigators say, that company you put together, you know, we're going to sue everybody behind it on an alter ego or piercing the corporate veil claim. And what that means is that the company, there's something wrong with the way you ran the company. And because of that, we're going to get behind it. They're going to say, gee, you didn't have directors meetings, and you never had shareholders meetings. And you did all these things wrong. You didn't properly capitalize it. You didn't form it correctly. You didn't sign all the paperwork, all this stuff. You did it online instead of using a lawyer, and you messed it up. And because of that, we're going to sue you personally. I want to tell you two things about that. Number one, I do startups. 90% of them fail. I've been doing it for 37 years, believe it or not. And I've done thousands of them. So I want you to just do the math. How many companies have I worked with that have failed? I've heard this claim maybe hundreds of times. I have never once, any company I've worked with, seen anyone get tagged under it. I've never once seen it succeed. Okay, in a company that I work with, all right? I know it happens out there in the ether. So I'm telling you, if you do things correctly, this is a wholly avoidable claim. Now, what is the one thing you can't do? What's the cardinal sin here? What is the thing that is that I can't help you, Batman can't help you if you don't follow this rule. You can't commingle, right? If you commingle, then all bets are off. All right, but every well-advised company will know not to do that. What do I mean by commingle? You don't use your company's bank account as your personal bank account. The company doesn't pay your personal expenses, and you don't use one account for personal and business expenses, because courts, they don't really want to punish you for being silly enough to go incorporate your own company online instead of hiring me. They don't want to punish you for that, as foolish as that is. But they will punish you. They will follow the money. They will follow the money. They will punish you for taking money out of the company and commingling it with your own. So that's the one thing to watch out for. Fiduciary claims. So once a company becomes insolvent, these are the fiduciary. I'm not going to go through all these. The fiduciary duties that you as a director have, and sometimes as an officer. The fiduciary claims I want to talk about for companies that start to go downhill is that if you have an insolvent company, debt exceeds assets. In a lot of states, including Delaware and California, you owe a duty to the creditors to act in their interest, their best interest. And some courts say, well, in fact, that company, that's just a trust fund. You're just holding money for the creditors. The equity has nothing in it. There's not enough value there to pay the equity. So really, you're acting on behalf of the creditors. So be careful. You have duties to creditors, and you will have to consider those. That's the fiduciary claims by creditors problem, and it's a little bit of a tricky one because when are you insolvent? And the trickier part is, if you look at the technical definition of insolvency, I think every startup I've ever worked with has started out insolvent. Certainly every startup that took convertible debt, to get funded, that used debt funding to get going was insolvent. So it's one that we need to pay more attention to probably than people do. All righty, now I want to talk a little bit about venture financings and what happens when you have a troubled company and the investors start to get concerned. Okay, so number one, first thing that might happen that you might see in troubled companies is a recap or a reset. We reset the cap table. Now, when those of you who are venture financed, you'll notice that in your documents, there's a clause that says by a majority vote of the preferred stockholders, they can agree to convert all of the preferred into common stock. Now, you might be saying to yourself, gee, that's really silly. Why would anybody do that? Why would a preferred stockholder vote to convert their stock into common? They got preferred and are going to vote to take common instead? Yeah, they will do that. They'll do that as a recap because we need to get rid of the preferences of the companies going nowhere. You all know how preferences work, right? That's the idea. When a company gets sold, the preferred stockholder, they get the first money out equal to their preferences. If they put $1 million into your company and they got 1x non-participating preferred stock, that means you sell the company, they get the first $1 million out. Well, sometimes those preferences exceed the value of the company. And that means that you, the common stockholder, the founder, you've got no incentive to really work to sell that company. You got no incentive to do much of anything. You got this big preference stack on top of you. So the preferred will say, well, okay, we're going to vote and we're going to convert all of that preferred to common, so there's not this huge preference stack on top of the common, and they've got an incentive to get their pro rata share of the proceeds of sale. So they'll go ahead and recap it. And there are other ways that we do this pull-up transaction where the new money, in other words, new money comes in and it gets to keep some of its preferences. Why would investors do that? We do that all the time. We call it pay to play usually. It's this contractual obligation that says, look, if the company needs more money down the road, you existing investors, you're going to put it in. If you don't put it in, you're going to have to give up those beautiful preferences that you negotiated so hard for. You might give up some other things, some voting rights, some anti-dilution protection, etc. It usually applies to future rounds. I see it come up in current financings all the time. Anti-dilution. So typically, a typical company has what they call weighted average anti-dilution protection. And weighted average typically means that there are some adjustments in case the company sells stock at less than the price that the investor paid, but there's a mathematical formula that means that the adjustment is it's not a dollar for dollar adjustment. Full ratchet means there's a full adjustment. So for example, if I'm an investor and I bought stock from you at $1 a share, and then the next day you turn around and sell that same stock for 50 cents a share, well, I get a full adjustment. I get twice as many shares. It's full ratchet. You only see that in troubled companies. You will only see that in troubled companies because it can be really bad on a company, especially when it's combined with preferences, down rounds, other things. I've told the story here many times on this forum about the client I had who built a company up and it got sold for $500 million, the founder, $500 million. And because of down rounds, participation and full ratchet, this particular founder ended up with zero out of that transaction. So you need to pay attention. By the way, I was not her lawyer at the time she negotiated those terms. I was her lawyer 10 years later to explain to her what a bad deal she made. So pay attention to this stuff. Repricing. Your company gets in trouble. You got options. Does everyone know what an option is? That's a right to buy stock at a certain price. And under US law, that price has to be fair market value as of the date that the right is granted. Now, what happens when a company goes down in value? Well, those options are underwater, right? They're underwater. They're not as valuable. People don't want the options anymore. They're not really helping anybody. So what are we going to do? We reprice them, meaning we reduce the exercise price. Those of you in the US, I mean, it's going to mess up your ISOs, no longer ISO treatment, but who cares? You didn't have any value in them anyway. And there are some securities law issues. It might be a tender offer. What I'm trying to say is that this is a pretty technical legal thing. There's a solution when your options are underwater. You can still reprice them and retain people, but follow the law. Carve-out plans, troubled company terms. This is public knowledge, so I can talk about it. I got this right out of the papers, even though I know some of the players in this pretty well. So company sale to BlackBerry, common stockholders opposed it. The company turned down some offers. Why did they oppose it? So the company had one offer for its sale for $825 million, double BlackBerry's offer. The board of directors, turned down the better offer, and they took the lower offer, and then everybody got sued, of course. Now, why is it? Why is it that they did that? You have to ask yourself, why did the directors do that? And this is a venture-backed company. You really have to look hard at what's going on in the board meeting and where the loyalties reside. So if you are the board member and you're in a scenario, be very careful about your fiduciary duties. We'll talk more about that, maybe not, but if we don't get to it, look up a case called In Re Trados, Trados. In this particular case, it was alleged that the management company pushed us through because they were getting this beautiful carve-out plan and retention plan, and the VCs didn't care that much because they were capped. They were going to get their preferences, whether it's 500 million or $1 billion. So they didn't really care, and they wanted to reward management. That was the allegation in that case. Troubled company terms. Let me jump ahead. Well, let's talk a little bit about this. If your company does start to go in a wrong direction, what you're going to see is investors, not only are they going to lower the valuation, they're going to maybe ask for warrants that cost a penny, which is a lot like just giving them additional stock. A warrant is a right to buy stock. I can buy an X 100 shares for a penny, as an example. They might trigger their redemption rights. When you did your financing, now that you're healthy, you might have found a little clause in there that says redemption rights. It pops up in later rounds. Redemption right means that the investor has a right to force the company to buy their shares back down the road. Resist that if you can, because they're only going to trigger it if things are bad. And if things are bad, you're not going to be able to pay the redemption price. And if you can't pay the redemption price, it means the investor ends up with your company or ends up being a creditor. Pay to play, we already talked about. Ideally, you want a successful exit. You want a sale or an acquisition at a good price. But I want to talk more about downturns. So the Trados shareholder litigation, let me talk about that a little bit, because that is really the one case everybody should read. Here we got a sale of a company. The board, again, preferences were eating up everything. So what the board did is they said, well, we're going to put in place this management incentive plan so that when we sell the company, the first $8 million off the top goes to pay management, because we want you guys to be incentivized to sell. And then the rest of it goes to pay the liquidation preference. The rest of the common stockholders get nothing. Directors voted on it, said, sounds good to us. And they sold the company, then everybody got sued. And here was the theory of the case. Remember what I said, directors, you can rely on the business judgment rule. No one's going to, you're not going to be liable if you just, you don't have to be a good businessman. You just have to be a careful one. Use your business judgment. That rule doesn't apply when you have a breach of loyalty, when you have an interested director transaction. In that case, there's a different standard, the entire fairness standard. And that shifts the burden of proof. It means you, the director, have to prove that that transaction is fair. Before, the court wouldn't even ask, business judgment. Now, not only do they ask, you have to prove it. So that was the rule. That was what the learnings from the Trados cases. We had an interested director transaction because everybody in this deal had some sort of stake in this deal. So therefore, we shifted the burden. So in that particular case, by the way, it was an empty victory because the court eventually said, yeah, it was fair. The process wasn't fair. What you did, it wasn't fair, but the price was fair. You got as much for these common shareholders, nothing, as they would have gotten in any scenario. So common stockholders lose. Of course, that's after probably millions of dollars of legal fees. So everybody lost, except us, the lawyers. Everybody else lost. What was the lesson from that case? Best practices. Have independent boards if you can. It's almost impossible according to Trados. View things through this entire fairness standard, which means you have a good process. You shop the company. You use bankers, right? You have meetings. You actually have meetings where people discuss these deals. You look at competing offers, and then you take separate votes if you have to. Well, alrighty then. We've already talked about personal liability. I'm not going to bore you with Section 382. It's a tax thing. Warren Act, that's a federal law that makes it really hard to lay off a lot of people without giving advance notice. All other things that companies need to worry about if they start into that downward spiral so that everybody doesn't get in trouble. But with that, I'm going to let you know that I am Roger Royse from the law firm of Haynes and Boone, Palo Alto office, and I'm going to open this up to questions. So with that, I'm stopping my share. I'm going over to my Q&A box here. And I see people have been using the chat feature instead of Q&A. So if you have questions, go ahead and type them in the Q&A. But while you're doing that, I'm going to go back to the chat. So this one is a little off topic, but I'll go ahead and address it anyway. Somebody's asking if it makes a difference or if it makes sense to start up a business in a state like Wyoming or Delaware. How about Nevada? Okay, I'm licensed in Nevada, by the way. Why might somebody want to start a business in someplace other than California? I think is what you're really asking. Good question. So even though I'm a California lawyer and I'm licensed in Nevada and 4 or 5 other states, 90%, maybe 99% of the corporations I form are under Delaware law, whether they're corporations or LLCs as well. And there are a lot of reasons for that that we could go through. I'll talk about a couple of them right now, but let me lead off with the one that's most relevant to our topic. Delaware has a really good body of case law on what it means to have fiduciary duties. In other words, what it's going to take for one of the creditors or shareholders of the company to tag you. Delaware has very clear law on that, and it tends to be pretty company favorable. Company favorable is what I'll say about that. So that would be a good reason to form in Delaware. The other reason is that's all the VCs will invest in around here anyway, in Silicon Valley. They want you to be in Delaware. The reason why, by the way, they might not even know this themselves, but the reason why is if you're a California corporation and a lot of other places, you have to have a class vote by statute. So if that acquisition in Trados, that deal comes along, somebody wants to buy the company, you not only have to get a vote of the majority of the preferred, you got to get a vote of a majority of the common, okay? Well, that means that the common can hold the company hostage. And if the common's underwater because the preferences are so high, you're a little worried that might happen, right? If you're a preferred stockholder, and that's what VCs are, they're preferred stockholders. So what they will do is they will require that all shares vote as a class on an issue like that, other than some protective provisions that benefit only the VCs. You can do that in Delaware. That's the biggest reason they go to Delaware. That and a good body of law and the fact that the Secretary of State's office is easy to deal with, et cetera. That's the big reason. Now, somebody asked here about Wyoming or other states. So a lot of companies are going to Wyoming for crypto. And I formed several of them myself because they have very, very lenient blockchain and crypto and distributed ledger tech regulations in Wyoming. So it's a great state to be if you're actually going to locate there. But keep in mind, you're still subject to federal law. Last time I was in Wyoming, I noticed it's still in the United States, almost in the middle. So you still have to deal with the federal rules and federal regulations. You just don't have to deal with something silly like a New York BIT license, okay, if you're in Wyoming. And you're doing business in Wyoming. So there's a good reasons for being there. I don't think there's good reasons for being for incorporating in another state unless you're actually there. If you have a physical presence there, yes, but otherwise there's no other state other than Delaware I would go to. 10 years ago, I would organize in Nevada because their corporations code was so friendly and they're so easy to deal with, but not so much anymore because they have it's complicated in Nevada, believe it or not. And I'm licensed in Nevada. I do work there, but they have a business license requirement. And it tends to be a little bit more expensive. Okay, so here's another question. This is a reactionary device for ventures that take a dip or a dive. What specific legal action should we take at the very, very beginning? Yeah, well, look at these slides when you get them and think about this as the future and the future that you don't want. So what that means at the beginning is, avoid guarantees if you can, right? Or at least know what you're getting into. And those guarantees come up, all over the place and give it a little thought when your landlord says guarantee this, right? How would you like to be somebody on a commercial lease guarantee right now for a retail operation? But more importantly, think about these fiduciary duties. Be aware of the Fraudulent Conveyance Act or the Voidable Transaction Act. Be aware of your shifting fiduciary duties that may have shifted to be duties to the creditor without you even knowing about it because you're insolvent and you didn't know that you were. So I think even though this is all reactionary and these are trust fund taxes, be careful who you put in your company to manage that process. So it is sort of reactionary, but it's things that you should be forewarned about so you don't make any of these mistakes that I see companies make regularly over and over again. Okay, what are my thoughts on convertible notes versus safes? Okay, let's talk about this for a little bit. And again, if you have questions, even if they're in the chat, could you post them again in the Q&A so I don't miss it? So in the old days, well, let's do a little history. It used to be that there's this thing called a bridge note. And the bridge note would bridge between rounds. When I first saw one of these, it was the VC came in, they bought stock, and they did Series A, and they're going to do a Series B, but it takes forever, and you got to get enough money. You got to have one big closing. The company needs money until then. So somebody, usually the early investor, would put money in, and that money would bridge to the next round, and it would convert into stock in the next round. And that got to be so popular that people started doing that even if they weren't bridging between rounds. So we still call them bridge notes sometimes. And in fact, there's a bridge in my background just to set up this question. So, but what they really are just promissory notes, promises to pay that will convert into equity when a company does a preferred stock financing. And we did that forever. Why do we do that? So that we don't have to value the company. So we've got a very early stage company. We don't have a valuation, doesn't have any traction, but it needs money. And we don't want to do a price round because we're the company, we're afraid of valuing it too low and the investor's afraid of valuing it too high. So the investor loans money to the company and that on a note, and that note will convert into stock when you sell preferred stock. Usually converts at a discount, meaning that like every 80 cents I loaned you gets $1 a stock or something like that. And also converts based on a valuation cap. What do I mean by valuation cap? It means that the money they loaned you is going to get some minimum percentage, no matter what your valuation is in the next financing, right? So if there's a runaway financing, and by the way, every lawyer I know made that mistake once in their career, representing an investor and not putting a valuation cap and watching the company valuation run away. And then we all never did it again. So that's a promissory note. Two problems with that. Number one, they had to be short-term. There's a regulatory banking law reasons for that. So if the company couldn't get to the next round within the term of the note, they'd be in default on the note. And most of the time, the lenders, they would just sit back and wait, until you did do a round. They understand how this game is played. I mean, why sue on a note when there's nothing there anyway? Once in a while, they would sue on a note and end up with the company, And even if they didn't, it was awfully stressful being in default under a whole bunch of promissory notes. Second problem, they are promissory notes. They had to pay interest, or they would be imputed interest under the tax laws. And that's a hassle, because look, why am I giving you debt return? This is really an equity investment, not a debt investment. We all know that. So why are we pretending it's debt? And that's where the SAFE came along. And that's a simple agreement for future equity. Think of it as a convertible note with no debt features. Doesn't have interest, doesn't have to be repaid. Investor puts the money in a company, same kind of thing as a discount and a cap. But if the company doesn't do a financing, the SAFE doesn't get paid and the SAFE owner doesn't sue the company and end up with it. So that's the difference. So here are my thoughts on it now that I've defined them. I'm a big fan of SAFEs. I do them frequently because I'm normally company side. When I'm on the investor side, I'll live with SAFEs because it's gotten to be a standard in the Valley. I might push for a convertible note from time to time because it's a little better deal for the investor. but most investors will settle for a safe. It's simple, right? Or it can be simple until lawyers get involved and it becomes complicated. But by the way, we do a whole hour on that. You should come to one of our, or look at one of our videos on safes. What I find though is in Silicon Valley, you say safe and everybody accepts that. Companies, investors, everybody else. You get outside this valley and people start wanting promissory notes again. They want convertible debt. They want convertible notes. And given that about half the people here are from outside, actually 60% of you, maybe more, 70% of you are outside Silicon Valley, you're probably going to see more promissory notes, convertible notes than I would. If you're on a company side, push back real hard and try to get a safe. It's just, I think, a much better way to go. All righty. Somebody, and the question is, what is your email address? Okay, okay, I'll put that. Actually, let me do that right now. Any questions, go ahead and put it in the Q&A rather than the chat. Let's see what else. What else do we have? I'm going to go through the chat here, so give me a minute here. You know, I'm a lawyer, so I can only talk about law. Somebody asked me what I think about investing in crypto and smart contracts. I actually do quite a bit of work with blockchain distributed ledger. And yeah, I will give you my view because I'm not an expert on this, but big surprise, I have an opinion. And even before Elon Musk bought Bitcoin or Tesla bought Bitcoin, I just think 2021 is a year that's going to be big for blockchain, but I don't think it's going to be, well, I think public blockchain will do just fine, but I think it'll be a big year for private blockchain as well. And I think it's going to be a big year for cryptocurrencies generally, just because there's so much money out there in the system that it's like gold, you know, like commodities, people are going to look for stores of value. So that's my view. All right, what is the lesser of two evils? Convertible debt or a priced round? Okay, good question. Thank you. So the priced round means that you're basically selling stock to somebody. And remember what I said, we do convertible notes and safes primarily so we don't have to value the company. We value the company at some later date when we do an institutional financing with a professional investor like a VC. So we know we're tagging along with the terms they get. That's convertible debt, but you'll find some investors, a lot of angels will say, wait a minute, I don't want to do that. I've been burned before. I know what's going to happen. That VC is going to come along. They're going to make me give up all my rights and all this other stuff. And the value is going to be too high, or I don't like your cap. I want to price this round now and I want stock in your company. Okay, that's a priced round. Now, one reason you don't do that is because of the valuation. The second thing, and this is one that, I don't know, this is maybe more controversial, but it's just the cost and expense and hassle of negotiating preferred stock documents. It used to be that was just a really big deal. It's a big thing. So a friend of mine over at Brand X Law Firm about 10 years ago came up with some Series Seed documents, which are very simple, stripped down preferred stock documents. So you could do a priced round, but do it at a cost comparable to a safe or a note. And those documents are out there, and we do Series C deals even today. And that's not a bad way to go. If you really have to price the round, we'll do it that way. For God's sakes, do not sell common to raise money. Say that again. Do not sell your common stock to raise money. Use some watered down vanilla Series Seed to raise money. What's the difference between Series Seed preferred and common? The preferred stock has a preference. So you can justify it costing more than your common. Why does it have to cost more? Because you want your common stock to be priced really low. You want it priced really low so you can give it out like candy to your employees, consultants, etc., in the form of options. And options have to be priced low because remember, the optionee, they get the spread, the increase in value. You sell common to raise money, you're going to push the price of the common high, or you're going to push the price of the stock too low. Series Seed, higher price than common, so you get more bang for your buck. So which is the lesser of two evils? Between convertible debt and priced round, I'd rather have the convertible debt just because of the, sorry, but even though it's Series Seed and they're supposed to be really simple, I rarely have that happening. Okay, I rarely have that happening. Why? Because you get lawyers involved and they start to monkey with the documents and add clauses and come up with bright ideas, and pretty soon you got a full-blown preferred stock financing. So I'd rather just do a simple convertible debt run and be done with it. And I'm usually on the company side. That's probably why. All right, somebody asked me for a checklist here for companies that want to go public. Well, not just going public. How about, let me click on some of these that I've already answered. Not just going public, but how about getting ready for an acquisition? Now, we do a whole session here on preparing your company for acquisition. And because we're talking about a down economy, let's suppose that you're getting ready for a sale in a down economy. Maybe it's not a great sale. Maybe you're not going to get all the money that you wanted to get. That's a whole different kind of deal than a sale where everybody's preferences are covered and there's enough left over for the common and maybe a bonus for your MIP plan, your management incentive plan. So, where was I? I'm reading the chat. So what is the checklist? Yes, there are checklists. If you want to email me, I'll send you some. But the checklists ought to be, board meetings. They ought to be independent boards, committees, ring fencing some of the members from some of the decisions, running a process, making sure that process is fair, using bankers if you have to, things like that. And also a really good review, of contracts, of documents, of potential liabilities, and minimizing any liabilities. So the way I do this is I set up a hierarchy, and I just want you to know that not all liabilities are created equal. So we'll say, here's what the company's got that it has to deal with. These are the ones that are going to bite you personally. You got taxes, you got wages, you might have some risks. You haven't made your 401k company contribution, stuff like that. Maybe you didn't pay your sales tax. Not telling you to pay those first. I'm just telling you that if they don't get paid, you personally are going to be on the hook for them. Then we got the next tier, secured liabilities. These are the ones, if you don't pay them, they're going to come and start carrying computers out of your office. Okay, and then we got everything else, which is the general creditors. So you at least ought to know about that. Now, why am I so careful about that? I'm glad you asked that. Let me pause on this for a second. Why am I so careful about that? Because remember what I said, you're an insolvent company, you have fiduciary duties to your creditors, to your constituency that you have to take care of. Well, if you prefer one over another, are you satisfying your fiduciary duties to your creditors? I don't know, maybe not. Maybe they're going to say, no, you paid that one because you guaranteed that debt and you breached your duty of loyalty to me. So we need to be super careful about this, but also aware of both the risk, and we have to weigh those risks, those relative risks, how bad they can be. And sometimes it'll just be like, let's just go ask a bankruptcy judge to bless this, and so you can sleep at night. No, nobody's going to sue you. We'll let them decide who gets paid first. Sometimes you just have to go that route, as bad as it is. There's something else about that. I wanted to tell you about that. Yeah, it's the bankruptcy option. Notice we didn't talk at all about bankruptcy in this presentation. I'm not a bankruptcy lawyer. I know a little bit about it, but this is really a presentation on what to do to stay out of bankruptcy. This is a presentation on what to do, basically to wind down a company without having to worry about these things. And even though your company has not been successful, because bankruptcies are very, very expensive, and there are other alternatives to it. Let's talk a little bit about that for a minute. Number one, let's say the company has not done well, so you're going to pull the plug, you're going to sell the assets and exit. The way I view it, there's really three ways you can do this, maybe four. One is, we'll call it a friendly foreclosure. We'll call it self-help, right? And in the self-help scenario, you just sell the assets and you decide who gets paid, you pay them, and everybody else, if they don't get paid, if there's enough money to pay everyone, that's great. If not, somebody gets stiffed. A lot of risk in that scenario, because the creditor who gets stiffed might come back and say, why'd you pay that guy and not me, right? So that's a little bit risky in some companies, not so risky in others. So for a lot of companies, that's what they'll do. They'll just close the doors and say, look, there's not any money to pay anybody, so I didn't prefer anyone. That's what usually happens. I'm going to circle back on that in a second. Scenario number two, yeah, I'm kind of worried that someone's going to come. We got this one big secured creditor and we got these other debts. And I want to have a little bit of protection. I heard you, I watched the Tiger King, and I don't want to, end up getting sued for fraudulent transfer because the buyer doesn't want to, who buys this business, because they might not pay enough for this as what it's worth. And then the creditor is going to go sue the buyer for the difference. So we do what's called an ABC transaction, assignment for benefit of creditors. It's a state procedure that gives the buyer some protection. Not a lot, but it gives them a little bit of protection against that fraudulent conveyance claim. And the protection derives from the fact that they run a process, a public bidding process. And that's pretty good. For most companies, they'll stop there and say, we're comfortable with that. We don't feel there's a lot of risk. And if we're not, then we do the dirty deed, the BK, the bankruptcy, just throw the whole thing into bankruptcy court. Now, if you are going to considering bankruptcy, let me just, I've been there many times. I've been a witness, I've been a lawyer. I could tell you stories. And one story I do want to tell you is that if you are heading that way, if you got real problems and they can only be worked out in bankruptcy, you have to be as clean as a houndstooth, okay? No cuteness at all in bankruptcy court. Bankruptcy judges do not like that at all, not at all. None of these games about preferring creditors or transferring assets or hiding assets or anything like that. You can get in real big trouble. So just keep that in mind. You do need a bankruptcy lawyer, which is not me, to advise you if you're going that route. On the front end, suppose you're going to wind the company down, you're not going to go bankruptcy, you're not going to do anything like that. Question I get a lot is, can't I just abandon this company? Just walk away from it? What do I care? I mean, I'm not liable. You just told me nobody pierces the veil. Yes, but I don't think you should. I think you should go ahead and go through a formal dissolution procedure. Why do I say that? Number one, if you don't dissolve, here in California anyway, our franchise tax board is going to be sending you notices. They're going to dun you for taxes for years. And even though technically they can't hold you personally responsible, that won't keep them from trying. And they do that in this state. And they do that under an alter ego pierce the corporate veil theory. Wait, didn't I just say those cases hardly ever win? Yeah, but that doesn't keep people, especially a governmental agency, which has almost unlimited resources, and by the way, really needs money right now, from going after people and bringing one of these suits. So I couldn't live with that. I couldn't sleep with that. I'm not sure I would want to do that. I want to just dissolve. Secondly, we have statutes of repose in California and in other states. And under those statutes of repose, some of the liabilities that you or your company might have, they're going to go away after a certain amount of time, provided you follow the process and the procedure for dissolving companies in California. So that's another reason I like to just kind of go through the statutes, just tie it up in a nice little bow. All right, let's see what else we've got. SBIR funding, holy cow. Unfortunately I'm not, but I'm getting that question a lot lately. So something must be going on. I'm seeing a lot of SBIR funding out there. Maybe we'll do a presentation on it. I can learn about it myself. Okay, following up on crypto. People want to talk about crypto. Let me mark these as done. People want to talk about crypto, and do you think crypto is useless because it assists transactions among suppliers in different countries and currencies, and how often is it used to escape tax? A little off topic, but what the heck? Yeah, never to escape tax. Just forget about it. Don't do it. I don't even want to know you if you're doing stuff like that. I don't want my name in the paper along with yours. Plus, let me tell you about crypto. If you have a Coinbase account, like I did, let me tell you a couple things about crypto, because we do a whole series on this, but you ask about tax. If you had a Coinbase account and you were trading your cryptocurrency, your Bitcoin for Ether or Litecoin or something, you might not have thought much about it. But the IRS thought a lot about it. They thought that's a taxable transaction and you owe tax on that. And in fact, Coinbase now started reporting that transaction a few years ago. And a lot of people got caught. And the IRS came out with an announcement and said, look, we know that you all thought that wasn't taxable, but since January 1, 2018, that is taxable, and you better pay your tax on it. And the smart people did that, okay? And I saw a lot of them, and sometimes that was millions of dollars. It was amazing. I mean, incredible stories. God, I saw, teenagers who made, millions of dollars, trading crypto from their bedrooms. So, but some people played the audit lottery, okay, and said, well, look, they haven't caught me so far. How are they going to know for everything I did before 2018? Well, if you got lucky with that audit lottery, good luck to you. You've got 3-year statute, 6 years for understatement, never for fraud, by the way. So what I want you to know about this, though, is that there's a new sheriff in town. Okay, we have a new president, and one of his objectives, and there's a new IRS, and their objective is enforcement. And they announced a couple of times, as recently as this morning, their new audit statistics and how they're going to increase their audit activity. So what I saw as a tax lawyer over the last 10 years strikes me as almost a crime spree with what people were getting away with, because they knew the IRS wasn't going to audit them. It just doesn't happen that often. And that's going to change. So if you're doing anything with crypto, do not try to use it to avoid tax. You're going to get caught. Now, the second thing I want to tell you about crypto is that the tax law is way behind when it comes to this. There was an announcement, I guess about a year ago now, on taxation of hard forks and drops and airdrops. And if you read the notice, the first thing you would have thought is, do these people know anything at all about blockchain? So it was pretty confused, but it was also pretty anti-taxpayer. So a hard fork is generally taxable, okay? An airdrop is generally taxable. That's the IRS position. Now, I'm part of a task force that's trying to challenge that and talk some sense into the service, but be alert and be aware of the rules. So here's the two things. Be aware of the rules around cryptocurrency, because I think the tax aspects are probably going to surprise you. And number two, just be super compliant, because the IRS is going to be out looking for these things. They're going to be on the warpath, no doubt about it. Okay, somebody asked me about non-disclosure agreements. Any remarks? Yeah, I could talk for an hour about non-disclosure agreements. Since I only got 2 minutes left, I'll tell you this about non-disclosure agreement. When you enter into a business transaction with somebody, if you don't want them to steal your idea, you'll have them sign an agreement that says they won't use any confidential information they get from you for anything other than the business purpose. Again, I got 3 things about everything. So 3 things about that. So number 1, you need to ask for that at the right time, not too early in a relationship, never from a VC until after they signed a term sheet. And don't disclose anything you don't want stolen until that's the second thing. Don't disclose anything you don't want stolen until you actually get one signed. And the third thing is, not all non-disclosure agreements are equal. And just because big company hands you a non-disclosure agreement, says, here, sign it, it's an NDA, we're such good guys, we went and drafted it ourselves, so you didn't have to hire that expensive lawyer to do it. Yeah, be super careful about that. Oftentimes those things don't protect you for lots of reasons. They might have humongous carve-outs. They might have what they call residual knowledge clauses. My favorite kind of unfair trade practice in non-disclosure agreements is where a big company forms some little shell that has no assets in it, and they have that company sign the non-disclosure as if that's going to work, but I see it happen. So yeah, so the answer is, I think overall, it's just paper. At the end of the day, a non-disclosure agreement, you have to have it just so you can show that your trade secrets are really secret. But just keep in mind, it's just paper. Make it as good as you can. But the better approach is to have something that just can't be stolen. Just have such a good execution and a good team that nobody would think of trying to compete with you. Okay, we're out of time and 5 minutes over. So with that, I am going to hand it back to you, Jen. Whoops. Hold on, Jen. I'm gonna.
Wow, Roger, that was a lot of great information. I certainly learned a lot. Thank you so much. And thank you for being with us today and sharing your expertise and insights. Audience members, thanks for tuning in and asking great questions. See you next time.